Good afternoon. I would like to acknowledge that we are meeting today on the traditional territory of the Haudenosaunee, the Métis, and more recently, the Mississaugas of the New Credit First Nation. The Toronto area is still home to a number of Indigenous people from across Turtle Land. We are grateful for the opportunity to meet in this territory. Today, the report of the Motherisk Commission is being released. It is the result of intensive work over the past 2 years and the input of many individuals and organizations. There are a few I would like to recognize in particular. I would like to thank the youth, parents, and other caregivers who shared with us their stories about how they were affected by the Motherisk hair testing. We were moved by their experiences and inspired by their courage and resilience. I'd like to thank the Attorney General, Naqvi, and thank you as well to the Minister of Children and Youth Services, Mr. Coteau, for both of their ministry's support of the Commission. I would like to thank my lead Commission counsel, Lauren Glass, and my entire staff team for their hard work and strong commitment to child welfare. Their unfailing dedication and support were essential as we worked through the very difficult and heart-rending issues each day. Finally, I would like to thank the Ontario Association of Children's Aid Societies and all of the individual societies across the province. I recognize that the Commission's need for documents and information placed additional pressure on them. Without their cooperation and commitment, we could not have carried out our mandate. In January 2016, the Ontario government asked me to establish a review and resource centre, the Motherisk Commission, to assist people in Ontario whose lives had been affected by the hair testing conducted by the Motherisk Drug Testing Laboratory at the Hospital for Sick Children in Toronto. The Commission operated independently of government and was not in any way associated with children's aid societies or sick kids. My mandate was a response to the Honourable Susan E. Lang's independent review of the Motherisk Laboratory in 2015. Justice Lang found that the hair strand drug and alcohol testing that it conducted was inadequate and unreliable for use in child protection legal proceedings. She concluded that the use of this evidence had serious implications for the fairness of those proceedings. Based on data provided by Sick Kids, Justice Lang reported that between 2005 and 2015, the Motherisk Laboratory tested more than 24,000 hair samples for drugs and alcohol. The samples were taken from over 16,000 different individuals for child protection purposes. This Commission's guiding principles included working with children and youth to ensure that their voices were heard. Our principles also required us to ensure meaningful participation by Indigenous and racialized communities. Indigenous and African Canadian families are overrepresented in Ontario's child welfare system. The Truth and Reconciliation Commission of Canada and One Vision, One Voice in Ontario have illuminated for all of us the history of and legacy of systemic racism in child welfare. We undertook outreach and communications to connect with Indigenous and racialized communities. We also reached out to youth, parents, and other people who were directly affected by the testing or involved with the child protection system. The Commission's role was to review individual child protection cases between 1990 and 2015 and to provide information and referrals to counseling services and legal advice. Over the past 2 years, we reviewed 1,291 cases from children's aid societies across the province. This final tally is higher than the number of cases indicated in my report. We were still reviewing cases at the time of its writing. We made every effort to identify and review all cases involving Motherisk hair testing originating in Ontario, where children were permanently removed from their families and were under the age of 18 at the time of our review. Reliance on hair testing in child protection work and legal proceedings which went on for over 20 years, was manifestly unfair and harmful, whether or not it substantially affected the outcome of individual cases. The testing was imposed on parents and other caregivers who were among the poorest and most vulnerable in our society. There was scant regard for due process or for their rights to privacy and bodily integrity. Most of the parents who were tested were powerless to resist. They told us that they submitted to the testing under duress in fear of losing custody of or access to their children. In some of the cases we reviewed, parents were told explicitly that this would be the consequence if they did not submit to the testing. People experienced the testing, particularly repeated testing, as intrusive, stigmatizing, demoralizing, and demeaning. Children's Aid Society workers play a sensitive dual role. They help parents to develop their strengths to improve their parenting, and at the same time, they monitor them to ensure that they are adequately caring for their children. To do this, workers need to build trusting relationships with the parents and families they work with. Societies use the testing to determine parents' credibility and to investigate suspicions of substance use. Many societies insisted that parents achieve abstinence. This tipped the scales heavily toward the society's monitoring role. It damaged these important relationships and made parents dealing with substance use issues reluctant to reach out to their workers for help. The child welfare system is vitally important to children and families, but it is a system under pressure. Child protection workers bear a heavy burden of responsibility for the safety of children. They must assess risk and make difficult decisions about what would be in the child's best interests. As the Ontario Association of Children's Aid Societies wrote in their submission to us, the use of a forensic tool understood to be credible and reliable and promoted through a division of a world-renowned medical facility such as the Hospital for Sick Children was seen to provide a quick, trustworthy solution to ensuring child safety. In 2015, the Ministry of Children and Youth Services directed Children's Aid Societies to stop using hair testing, and Sick Kids shut down the Motherisk laboratory. However, as we learned through our discussions, since that time, there has been an increase in urine testing for drug and alcohol use from a number of different sources. Like the Motherisk hair tests, by and large, these tests are being admitted into evidence without proper scrutiny. Children's Aid Societies offered the hair testing as expert evidence in legal proceedings that determined whether children were in need of protection, and if so, who should care for them. The discovery that unreliable test results were used as expert evidence in these proceedings for so many years undermines the public's confidence in the fairness of the justice system, particularly with respect to how it treats vulnerable people. Child protection law has special rules of evidence. The rules recognize the urgency of protecting children and making decisions about their care as quickly as possible. However, the relaxed approach to admitting the Motherisk test results in the cases we reviewed pushed these less rigorous standards of evidence beyond what could reasonably be considered necessary or fair. As we reviewed individual cases, we identified and documented recurring patterns. Those patterns revealed how the laws and rules in child protection functioned to permit the flawed testing to be used for so long. We also saw how parents lacked the information and support they needed to advocate more strongly for themselves and for their families. Even in cases where the impact of the testing was substantial, the people affected have only a remote chance of achieving a satisfactory legal remedy. This was deeply troubling to us. We set out to engage many different partners and communities in a dialogue about making changes to prevent another failure, like Motherisk. We believed that such a dialogue could meaningfully address the issues we were identifying in the file reviews. We also believed that it would help us fulfill our mandate to help people who had been affected by the testing. We looked to restorative justice as a model for our process. It allowed us to work with others to investigate the systemic issues we had identified, share our perspectives, and together develop solutions. Over 250 people were involved in our process. They included people in communities affected by the testing, as well as child welfare workers, social workers, substance use treatment providers, lawyers, judges, academics, scientists, and community workers. Many of the recommendations in this report evolved from our restorative process. Over the past 2 years, Sick Kids, the Ontario government, and the Ontario Association of Children's Aid Societies have all taken important actions to address issues raised by the flawed Motherisk testing. But I believe that further changes are needed. I have recommended a number of amendments to the legislation and rules governing the use of expert evidence in child protection, as well as changes to strengthen the representation of parents. I have also recommended enhanced education for judges on their important role as gatekeepers for expert evidence in the child protection process. I have added my voice to many others who have called on the federal government to immediately provide adequate funding to First Nations for band representatives. I believe that there's also a role for the provincial government in supporting their ongoing training needs. The Ontario government should move quickly in consultation with Métis and Inuit peoples to determine how they will be funded to participate in child protection proceedings under the new child welfare legislation. I have made recommendations to strengthen the representation of parents involved in child protection proceedings and provide them with additional support. That support would come from system navigators, peer mentors, and social workers to assist parents' counsel. All of these supports would be provided independently of children's aid societies. I have also made recommendations to help parents dealing with substance use issues. These include enhanced family-inclusive treatment options. They also include strengthening partnerships between child welfare workers and substance use treatment providers. I've recommended that children's aid societies continue to involve parents and youth in dialogue and decision-making. They must also be supported to continue to work toward achieving equity in child welfare system. I have suggested changes to strengthen the practice of social work and the practice of child protection law. Finally, I have recommended that a stakeholder advisory committee be established to advise the government on the implementation of the recommendations in my report. The committee would also organize an annual child protection summit. I recognize that implementing some of these changes will add pressures and procedures to an already busy child protection and legal systems. Some of them will require additional funding. However, I believe these changes are vital. We must bear in mind the harm the Motherisk hair testing caused to families and the damage it did to the credibility of the child protection and legal systems. In 56 cases, I determined that Motherisk test results had substantial impact on the decisions made. Behind every one of these 56 cases, families were broken apart. Relationships among children, their siblings, parents, and extended families and communities were damaged or lost. Parents and other caregivers in these cases will find it difficult to obtain a remedy through the courts that would give them access or greater access to their children. Even if they are successful, they will have lost precious years with them. The decisions we make in child protection are often devastating and irrevocable. That is why it is critical that only reliable evidence and a fair process be used in the service of making those decisions. There's no certainty in child protection. The Motherisk hair testing seemed to offer that certainty, but it failed us. We must be much more careful about how we use expert evidence. We must provide more support to child protection and legal partners to challenge its reliability. And we must listen more carefully to children, youth, and parents about what they need and want. It is my hope that through the counseling and legal services the Commission offered and through our restorative process, some of the families harmed by the Motherisk testing will begin to find peace and healing. Some people who were affected by the testing may wish to seek counseling in the future. For this reason, I have recommended that free counseling services continue to be available upon request for 3 more years. Many of my recommendations focus on encouraging partnerships and dialogue among the people and sectors involved in child protection. All of them are essential in developing solutions to the systemic issues that led to the reliance on the Motherisk hair testing. Through our restorative process, I saw genuine commitment to the sustained collaboration needed to bring about the changes I have recommended. I propose my recommendations as steps towards ensuring that no family will experience similar harm in the future. It has been my privilege to serve as Commissioner. My lead Commission Counsel, Lord Glass, is available to answer your questions. Thank you.
Oh, okay. Now you tell me. Does anyone have any questions? Oh, sorry.
First of all, I'd like to congratulate the Commissioner and the excellent report, and it covered a lot of things that I could do, so we actually listened and turned it into what was here. However, I'm with Defense for Children International, and we always look for how could this be better for children. So I'm going to start with the first recommendation. If today a person is entitled to the full range of services from the resources, and let's take a younger person who doesn't really mature for more than 3 years, and I believe that that recommendation should be expanded so that it in fact covers a longer period of time, in fact as long as it's needed for people who are coming forward and have truly been harmed by the Motherisk process.
Well, I haven't been appointed by the Minister, the Attorney General, yet to expand on any of these recommendations, but I can tell you that in our discussions, it seems to me... Can you speak to the mic? Oh, I'm sorry. I was saying that we haven't had discussions about taking it further than that, but in our discussions that we have had, I know that the Minister is going to be open to at least hearing those suggestions, and I don't know what they'll do with them in the future, but I know they'll listen to them. Hi.
So 56 families, have all the families been contacted, and 56 families were affected to the point where there are some kind of processes in place where they can either reconnect with their family or legal?
No.
Okay.
56 cases that we reviewed, we found that the Motherisk hair testing had had a substantial impact on the outcome. And by substantial impact, we mean that it either guided how the Children's Aid Society was planning for a family, or how courts made interim or temporary decisions for that family, or how the court made a final decision for that family. So in 56 cases, we decided that yes, there was a substantial impact. But we don't have 56 families going forward to seek remedies. What we have of those 56, we have 12 that are currently in progress, where there's either court cases have been started or they're about to be started. We have 7 families where they've already had some degree of reunification, whether the children have been returned home, or there's increased access with the family, or there might be what's called openness under the Child and Family Services Act.
And my understanding then is if the children are over 18 now, they were not included in that investigation?
They were not included in our initial reviews, no. Because there would be no remedy available under the Child and Family Services Act. And in fact, some of the substantial impact cases we did discover, some or all of the children in those families were over the age of 18, so there would not be a remedy available under that act. Yeah.
Hi there. So what about the other cases? Is it possible that there are other cases in the larger number, or was this a sample taken And can you, do you
It was not a sample taken. We reviewed thoroughly all 1,291 cases that we received. Of those 1,291, approximately 740 were what we defined as high priority cases. So those would have been cases where children had been permanently removed from families. We also reviewed about 550 cases of what we called phase 2, where they were more historical, where kids had been made Crown wards, they may have been adopted, they may have been placed in the custody of someone other than their primary caregiver, and we reviewed those cases as well.
I'm sorry, I meant the 16,000 of all the tests that were done. Is it possible to go through those, or?
It was not possible, and if we look at Justice Lang's report, she spoke to that very clearly. She said that wouldn't be a good use of time or money in terms of looking at all those cases. She said what we should be focusing on are the high priority cases where kids have been permanently removed from families, and those final decisions have been made. And so that's what we did. We did exactly what Justice Lang had set out in her report.
All right. And then my last question is, how do you prevent this from happening again? If tests are being used right now to test parents' urine and other samples, how do you know that you can prevent this, the reliance on one particular test becoming gospel?
Well, I think that what we have to look at is the role that judges play in this process. There was an excellent decision that came out in October of last year where a judge said prior to a urine test being admitted into evidence, that person who conducted that test would have to be called and give evidence. They'd have to be qualified as an expert to be able to testify about the results of those tests. So that's really one of the recommendations that Commissioner Beeman has made in terms of tightening the rules around expert evidence. So we're hopeful that that is one way. Another way is looking at children's aid societies and saying to them, don't look at a urine test as necessarily deciding if someone can parent or not. Look at their overall parenting. And I think the children's aid societies in this province have started to do that more and more and more.
On that note, should we be moving away from looking at abstinence as the only kind of measure of whether, is that the only option, or could there be a more nuanced way of looking at alcohol and drug use in parenting?
I think absolutely there's a more nuanced way of looking at it, and I think many of the children's aid societies in this province have started to do that. We saw lots of cases where people tested positive at Motherisk, and yet children were returned subject to terms of supervision, and societies continued to work with those parents with those kids. So abstinence wasn't the only rule for every agency in this province, and I think we're moving farther away from abstinence as the only way to go. Rachel?
Hi, thanks.
We're on a first-name basis.
Thanks, Lauren. So just following up on the 16,000 question, what if children or parents come forward later after the commission mandate is over and want a review of their cases? What can you do for them?
The Motherisk Commission can't do anything for them. But I think if they discuss that with the Minister of the Attorney General, that ministry may be able to consider something. That I don't know, but the Motherisk Commission is at an end.
And my other question is, my understanding is that in cases where you didn't find a significant factor, those families were not informed of that. Is that correct?
That's correct.
So if the commissioner was offering a reconsideration, how could those families ask for a reconsideration if they didn't know their case had been reviewed?
Well, sometimes they were advised about the outcome through an agency. We did know about that because we did have some of those reconsiderations come in. In some cases, those families reached out to us after we had already reviewed a file. And so they then requested that reconsideration that way. We did a lot of outreach. We had posters up a lot around the province. We also gave lots of talks around the province to various groups. We gave lots of talks to kids and kids groups. So there were ways for those families to find out what was going on and to contact us, even if they didn't know we had already reviewed their file. So we did have those situations where we did speak with those people.
And sorry, one last question. We know that in 1993, a court in Colorado threw out Motherisk's evidence as unreliable for many of the same reasons that Justice Lang later identified. Why did it take so long for these concerns to come to the surface in Ontario?
Interesting question. I don't have a good answer for it. The Motherisk Laboratory was viewed as doing good work, despite what went on in Colorado and despite what that judge found there. It wasn't until Justice Lang did her review that really the unreliability of that the testing done in that facility came to be known by everybody else. But up until that point, we were looking at Motherisk as a reliable test. And, it's interesting because, it was a criminal case where they found the unreliability. A doctor from Alberta, Dr. Chatterley, questioned what was going on at Sick Kids, and that's really what started it in Ontario. Yes?
So, just based on what I'm hearing, am I right that of the 1,291 cases, outside of those, there was no review of cases where children were perhaps temporarily removed from their parents' care as a result of Motherisk testing?
No, in many of those cases, kids had been temporarily removed and eventually were returned. By temporary, that could have been a period of up to a number of years, not only days or months. But in many of those cases, kids had been what you call temporarily removed and had eventually been returned to their families. Okay, well, thank you all very much.
Good afternoon. Annie, bonjour, bonjour. I'd like to acknowledge the diverse Indigenous people here in this province and just recognize the long history of our Indigenous partners here today and, of course, across this great province. I'd like to thank the Commissioner for her and her team for the report that they've produced and the recommendations we are receiving here today. At first glance, I've been able to look through the official report, but I've been updated by my ministry, and I believe that they've produced a very thorough, a very thoughtful report and provided government and Ontario with a pathway forward. I want to thank you and your team for your dedication and all the time and effort that you've put into this report. I also want to take a moment to acknowledge the families impacted by the flawed hair strand testing at Motherisk Laboratory. What happened there is heartbreaking, and there's no question it's a tragedy. And I just wanted to acknowledge the families who are joining us here today. I recognize how difficult the process has been to those who came forward to tell their stories. I understand how painful it was to revisit those stories and those experiences. And I want to thank you for speaking up, and your perspectives have already started to guide us on a better path forward. I'm committed to continuing to support you through what I'm sure is a very, very difficult time. That's why counseling services will remain available for those who need it. Today's report has identified critical issues in the child welfare system. As the minister overseeing this sector, I can tell you our work to transform this system and putting the child at the center of decision-making is already underway. But what I think is most important about this report is that it illustrates that sectors cannot operate in isolation when working to support families and children. That's why I'm here today alongside the Attorney General and on behalf of government to accept these recommendations as we work to build a stronger, more integrated, culturally appropriate service that better respond to the needs of vulnerable parents and children. We know that all too often it is the most vulnerable people in our communities who come into contact with the child protection system. We know that those living in poverty, as well as members of the Black and Indigenous communities, are overrepresented in the child protection system. So we're looking for ways to change that. As a first step forward, we are establishing a committee with our partners from all across the child welfare and justice sector, as well as families, Indigenous partners, and with the Black community. And we know that work is already underway. We've passed, modernized, and build legislation to make it more reflective of a system that we believe is necessary here in Ontario. We're working with the Anti-Racism Directorate and will continue to target systemic racism, which is deeply entrenched in our day-to-day lives and institutions we rely on for critical public services. And working with the child welfare system, we will continue to emphasize a preventative approach to supporting families, working with them before they reach crisis situations. As an MPP, as a minister responsible for Children and Youth Services, minister responsible for anti-racism here in the province, but also as a father of two young girls, it's important to me that we do everything we possibly can to empower and support children and youth here in Ontario, especially the most vulnerable, so that they can reach their full potential. We are committed to giving children the best start possible in life. We are committed to helping our youth as they prepare for the often challenging transition into adulthood, and we are committed to ensuring that children, youth, and families have access to services and the supports that they need. So we take these commitments very seriously. Promoting the protection and well-being of children and youth is not just an obligation as leaders entrusted to shape the future of our great province. I believe it's our moral imperative, our duty, and our privilege. Commissioner, I know the Commissioner and the government, we recognize that the Motherisk hair testing process was unreliable, and it has caused much harm to families here in Ontario. We are committed to helping ensure that similar tragedies do not happen in the future. We are confident that with the help of our partners in the child welfare and justice sector, we can continue on a path to transform the child welfare system to better serve children and families here in Ontario. I'll pass it over now to the Attorney General.
Thank you, Michael, and good afternoon, everyone. I too would like to thank Commissioner Beeman and her team for this very important work and the report they have produced today. I also want to thank them for their compassionate and thoughtful approach to their review. This report, as you heard, is based on a comprehensive review of more than 1,200 cases. Behind every case, there are children, parents, grandmothers, and grandfathers. In some cases, entire communities who have been impacted by this tragedy. And it is a tragedy. If even one family was ripped apart unjustly, that's a tragedy. Very similar to Michael, I'm also a father of two young children, and I can't begin to imagine how that must feel. And as Attorney General, I find it completely unacceptable. We have been tasked with turning tragedy into change. And so I pledge to all those families, to Commissioner Beeman, that our government will work to address the issues raised by the Commission. The Commission's report importantly takes a holistic look at how families interact with the child welfare and justice systems. It raises the need to build stronger, more integrated and culturally appropriate services and supports that better respond to the needs of vulnerable parents and children, particularly those belonging to Black, Indigenous, and other marginalized communities. All too often, we hear that government agencies and other public sector bodies work in silos, focusing on ministry or department-specific needs rather than the system as a whole. That approach simply does not work when it comes to child welfare matters. As Commissioner Beeman explained, these cases are incredibly complex. And from a parent's perspective, the process must seem incredibly daunting and difficult to navigate. To really serve the best interests of both children and parents, and to be effective as a system, the child welfare and justice system must work together. Of course, this will be no easy task. Commissioner Beeman's recommendations span at least 17 separate entities, including my own ministry, the Ministry of Children and Youth Services, as well as several partner organizations from across the broader justice and child welfare sectors. We will need the help of all of these organizations if we are to successfully address the issues that this report reveals. As Attorney General, one of my first steps will be to write to the key partners in the justice sector, including the Judiciary, Legal Aid Ontario, the Law Society of Ontario, and the Family Law Rules Committee to ask them to consider their relevant recommendations that are outlined in this report. These partners will be critical to moving forward recommendations regarding education on expert evidence and amendments to family law rules. And as Minister Coteau mentioned a moment ago, we are moving quickly to form a task force to help us with implementing other recommendations that are outlined in Commissioner Beeman's report. We will also reach out to our partners in child welfare and forensic science, as well as families, Indigenous peoples, and the Black community. Their perspectives will guide us as we determine our next steps to address the recommendations in a coordinated, culturally appropriate manner. But we know that for those families who were failed by the system, these words may not seem like much. We know for many, trust in the system has been damaged or lost altogether. So to demonstrate our commitment to change, to rebuild that trust in an open and transparent way, we will report publicly on our progress within 1 year. I want to thank each of you for being here and your contribution to the work that Commissioner Beeman has done. To Commissioner Beeman, her team, and the many experts and individuals who contributed your time and expertise to the review process, thank you again for your part delivering this significant report. And I want to thank the families who participated in this review. Sharing your stories took courage. Though we cannot change the past, we can and will take every necessary step to help you find peace and healing and make sure this never happens again. With your insights and the thoughtful recommendations of Commissioner Beeman, I am confident that we can continue the path of transformational change that is needed in our system, and to ensure that it is one that all children and parents can trust and depend on. Thank you, and Michael and I are now available to answer any questions that you may have. Thank you very much.
Hi, this is a question for Minister Coteau. It seems like every year there's a new report, a new coroner's inquest, a new review that highlights some deep and really troubling flaws in the child welfare system, and you're forced to kind of address these all separately, reactively. Is there any plan to look at the system as a whole proactively and highlight these issues rather than dealing with them separately as they come up year after year?
No, I think you're absolutely right. What we're seeing today is a long legacy, I think, of the way the system has been built. There's been some systemic issues that have been at play, and I believe systemic racism at play when we talk about communities like the Indigenous community and the Black community. We've built new legislation. It was the first piece of legislation that I believe was comprehensive enough in 30 years to reflect the current needs. You'll notice that the piece of legislation I introduced to reform the child protection sector, just services for young people, is the first piece of legislation in this country that acknowledges that systemic racism actually exists, that the system itself needed to be reformed. It looks at it highlights Jordan's principle. It talks about putting the child at the center of decision making through regulation and complementing the legislation through our blueprint for residential care. All of those pieces together, I believe, especially with the work with the Anti-Racism Directorate, we're addressing a lot of those issues. And as regulation starts to come forward, you will see a lot of that, a lot of those concerns concerns that you've talked about that are highlighted in the legislation actually go into practice. So I think we're at a very important time in our history in Ontario where there's a full acknowledgement from government that the system itself systemically was not positioned well to support children from Indigenous communities and Black communities and other marginalized communities. And going forward, based on the legislation that we've built, we will bring change here in Ontario. Yeah.
My question's for Minister Naqvi. So 10 years ago, Justice Gouge came out with a report that was aimed at making sure something horrible never happened again. And that, of course, involved the scandal involving Charles Smith, who was an expert at sick kids. And that scandal, of course, tore apart families and disproportionately affected marginalized Canadians. And so what is it now that, how can we be so sure that once again, here we are, the Attorney General has called this review and this commission, and we have another host of recommendations aimed at, again, ensuring that a scandal involving marginalized families, an expert from sick kids, and families torn apart doesn't happen again. How can we be confident that this time we're going to get it right?
Well, I wish it would have not had happened in the first instance, and I wish it would have not happened in this instance. I don't think anybody out there intentionally goes out and saying that we should rip families. As Michael alluded, I think there has been some serious systemic issues within the system that we are working hard in addressing. And as we know, when you're dealing with systemic issues, you cannot change everything overnight, but you need to get the fundamentals and the foundations right. And similarly, as the government implemented Justice Gouge's report, we are committed to doing the same as outlined by Commissioner Beeman. There's a lot of work that needs to be done. As she mentioned in her comments, this stuff cannot happen overnight, and that is why we want to immediately create a task force focused on implementation, bringing all the partners together along with racialized communities and our Indigenous community being part of their work. That is why we're also undertaking to report back within 1 year. Because I think it's important that families across the province and all the partners, all of you who work in this area, know exactly what's happening and how his government is going to move forward, that we have robust systems and checks and balances in place. So I hope in my role, or no other future Attorney General standing in front of you in the future and saying that this will never happen again, that we are, in a very meaningful way, are able to address these challenges.
I'm not sure where we are at the stage as far as compensation for the families involved.
So I haven't had the chance to read the report, so I'm not sure whether Justice Beeman speaks to compensation. I think there may be cases, court cases that may be within the system right now, so it's difficult for me to comment in that regards. Our focus remains to ensure that we implement to work on the recommendations, and that's why we want to create the task force as well. If that's one of the questions that we may want to pose to the task force to give us advice, that's probably one of the avenues we may look at.
So I'm sorry, does that mean that there's just no plan for across the board or a systematic compensation, that you're waiting for people to go through the civil courts process in order to do it case by case?
I mean, we probably have to look at cases case by case, and the reason I'm a bit reluctant right now is because there are cases within the system. But what I'm also suggesting is that it's the question that we need to address and we need to look at, and we have not made any decisions at the moment in terms of what the path forward will be as it relates to compensation.
Just more, sorry. I don't know which one of you actually will take this, but there's some concerns raised now, the Commissioner said, about other forms of drug testing as part of these, the child protection process. And so I know that there had been, I guess, a policy of no longer using Motherisk, but is there some other kind of policy as to how drug testing needs to be used in child protection cases overall, and whether or not that would apply to urine testing or any other kind of testing that's being done now?
Right. Considering where we've come from in the last few years with this experience, I know that when Children's Aid Societies are making recommendations, they need to think about many different factors, and the recommendation coming forward always has to be obviously in the best interest of that child. In regards to testing, I don't believe at this point that there's a standard testing process that they're using. But I do know that when making a decision, you have to it can't just be a blanket decision based on one simple factor. It has to be the full picture. So I don't know what the future of drug testing will look like in this. Everything changes, technology changes constantly. But I know at this current moment, when we're making decisions that are in the best interest of families and young people, it has to be a full spectrum of decision factors to get to that decision point.
Hi there. I just want to know, how are you guys going to ensure that these recommendations are going to be not only implemented, but will actually yield results?
So, as you, if you have not had the chance to read, you will see, and as we heard from Commissioner Beeman, these are quite broad-ranging recommendations that have been presented. That they just not relate to one government ministry or just one agency out there. I mean, they apply quite broadly. So we need to make sure that that we are taking a systems-wide approach, that we are dealing these recommendations in a holistic manner, so that they do produce yield result, and they are able to speak to each other on a system-wide basis. And that is why we are immediately acting on the recommendation that Commissioner Beeman has made, and I think it's a very wise recommendation to create an implementation advisory group. So we're calling it task force. I think we need to bring the experts within the systems along with the relevant ministries all at the table, so that they can go through these recommendations. They can determine a bit of an action plan as to how we implement, how we go about these recommendations and addressing them, that would will result in the manner that we want them to. This is not the first time we're doing something like this. I go back to my experience working on the Elliott Lake recommendation when the roof of a mall collapsed. That was another report, a commission report that touched many ministries and different agencies, and we really had to bring people together around the table to make sure that it's change that we were bringing was coherent change, and we were quite successful. And we did yearly updates on that as well, and we were able to then do all the policy change, regulatory change, legislative change, and there was a little bit of everything in that, so that the system works in a comprehensive manner. I reckon that that's exactly what I think the approach would be. But the first step is an important step, which is to create this task force, bring the relevant people together, and start working together.
Any idea on how exactly to capture these results, though, right? Because ultimately, we want to see that change is going to be happening, but any way so far on how exactly we're going to capture this?
So I think, and I haven't gone through the report in detail, it's just been presented, but I know the general themes in relation to child protection sector. A lot of the themes are aligned with the direction the government's been going in. For example, when we talk about cultural competency, we've been moving in that direction. Our legislation speaks to it. We've funded, for example, the One Vision, One Voice, which is $1 million investment to build cultural competencies within the child protection sector. I know our Children's Aid Societies have started to, for example, put together parent advisory committees. I know Toronto does that, and others are going in that direction. Even when we talk about our Indigenous partners here in Ontario, we have 11 well-being, children and youth well-being centers that, so the community itself is in control of the Child Protection Agency locally. In fact, this Friday I'm at Six Nations and we're moving forward on another one. But we've gone even further with signing agreements with Treaty 3 and the Anishinaabe Nation. We're going for, the creation of their own local laws. The full jurisdictional control in the community. So it's a direction we're going in. I think those pieces are, capture a lot of the spirit of what the report talks about. The renegotiation with the federal government and bringing Indigenous partners to the table to renegotiate the way in which we fund child protection, rather than just looking at the services when a young person's in crisis, but looking at all of the services needed so we avoid the crisis in the long term. So looking at the services prior to a young person going down a pathway where they may end up in those types of services. So I think the report itself is very aligned with the spirit of the government and the direction it would like to go in. So I think that there's a lot of connection points and things that are happening already. And I look forward to embracing these recommendations and moving forward with them at our ministry. And I know Yasir and the government as a whole feels the same way in regards to capturing the spirit of the direction and making sure we go forward with those recommendations. But it's going to take a little bit of time to get there, right?
A quick question about the counseling. Are you adopting the recommendation that says you're giving an additional 3 years of counseling to people affected, as recommended?
Yes, we are.
Further to my last question, where is Sick Kids in this discussion? Where are they in the recommendations, and where will they be in terms of making sure that something like this doesn't happen again, where they've been involved in, 2 of these types of scandals in the last 10 years?
I'm looking at Mr. Glass to see if this is more goes to the report, if he want to come back.
I don't know exactly if your question is aimed at compensation as an issue or oversight of sick kids, because I can tell you in terms of compensation, the order in council setting up the Motherisk Commission said clearly that we should not make any comment on criminal or civil liability, and we haven't. But as I think you would know for sure, and others around the room probably know, there are a number of lawsuits that are outstanding in the province. There's a class action suit that was commenced. It was not certified. There's an appeal going forward on that class action suit. So I think compensation is certainly an issue that's out there and is being talked about. In terms of the oversight, we've had discussions with Sick Kids during the period of the commission, and I can tell you that Sick Kids has made it very clear to us that they are taking this very seriously, that they've made changes in their hospital procedures and so on. So they're trying to make certain that these things don't happen. They're trying to educate doctors in terms of how to testify and deal with court matters. So I know Sick Kids has taken it very seriously.
Good. Thank you, guys.
Thank you very much.
Thank you.
Thank you.